Hi, my name's Jethro. I'm the director of SHIINE. The intent of this video is to show you that no matter how good a patent attorney you hire, and no matter how much you pay for that patent attorney, there is a significant chance that you'll get a patent application drafted and filed and maybe even get a patent granted that does not protect your invention concept. It's very important to understand this stuff. If you don't understand what I'm about to show you, this either may or will happen to you. What you're about to see is not a one-off. I believe it's happening around 20 to 40% of the time that startup, first-time inventors like you go to patent attorneys, pay a huge amount of money, and this issue starts to come up. So you're going to see an example where Tom Schultheis came to me, who is a US inventor who had already filed a US non-provisional patent application through a patent attorney, and came to me thinking that I might be able to help with getting a UK patent. He saw my videos online, thought he'd contact me. He didn't expect that I was going to find an issue with the patent application. That's not what he hired me for. But as you're about to see, what happened became extremely, extremely important. It's very important you know this stuff. Let's check out the example of Tom Schultheis' invention, the brush up.
Before I go on, I want to say that what has happened here is not the fault of Tom's patent attorney. It's a breakdown of communication which unfortunately happens a lot of the time between startup inventors who don't understand patenting and patent attorneys. Tom also went to his patent attorney very early before his idea was fully developed, and this can make it extremely difficult for a patent attorney to write you a perfect patent application. You should be aware that this is an industry-wide problem, not a one-off. It is your fault if your patent application is drafted defectively and fails to get you perfect patent protection. It is not the fault of your attorney or of Tom's attorney in this case. Now that you know it's your responsibility, you cannot complain if it happens to you. So this video is going to be a crash course in patenting for some of you. You won't have seen a video like this before, and there may be a little bit of shock involved. I'm going to show you how I was able to break Tom's proposed $6,000 patent in about 3 minutes. So let's take a look at Tom's invention, the brush up, again. This is the invention almost exactly as he showed it to me after having had his US non-provisional patent application filed by a US patent attorney. You can see the basic concept is that it adds upward and outward cleaning capacity for floor cleaning apparatuses. Let's take a look at the brush up a bit closer. Okay, so I just want to very quickly show you with a video on my smartphone Tom's kind of original and preferred version of the brush up. So you can see his invention here is kind of a brush that brushes upwards and outwardly and can go on the top of any kind of floor cleaning apparatus like brooms, vacuums, etc. So let me show you a little bit closer. So the first thing obviously you can see is we've got here the brush. You know, it can be any type of brush, but there we've got that. Now you can see this black part here, if I just bend this back a bit, you can probably see there's actually a spine inside here, and this is kind of metallic, right? This is very strong, so I couldn't bend this if I wanted to, but that's how it gets these brushes going outwardly from here, because this part of the spine, all of it's straight apart from the side bit, which is bent, kind of curved like this, a rigid kind of curved spine, and the brush goes out. Now if you bend that even more, you can actually get the brushes going all the way down to kind of 90 degrees or more. You might have seen that on some of the versions. So we got the brush and we got a spine for the brush. And that's one way of doing it, but another way, which is quite cool, and I'll just put a picture of that on your screen right now, is a flexi spine brush. So you could have the spine, instead of being kind of metallic like this and kind of pre-curved, you can actually have a very flexible rubber spine, and you can kind of put that onto the head of the apparatus or whatever it goes into, and kind of make it so that the side bit curves and therefore still kind of creates these outward parts here. So it's either rigid pre-curved spine or it's a kind of flexi spine that can be curved when it's applied to the apparatus. And then this part here is what, as we're going to see, this black part, this kind of base part you can see here, is what's called, we'll see in the patent application, Tom's attorney called a brush clip. So you can see that the spine of the brush kind of clips in. It's very tightly clipped in. It's pretty difficult to take it out actually. So this kind of possibly could be held as a base, but its main function is to clip the brush part in. Okay, so we got the brush element with its spine, and we've got this brush clip that it goes into. It could be a flexi spine as well that goes in there, but we got this version with a kind of rigid pre-curved metallic spine. And if I turn over, you'll see the next part of it is actually these little, well, we can see a little bit closer if I show you here. We got these mounting brackets. Now, here we've got two mini mounting brackets, and you can see there's a kind of hole or gap at the bottom of this brush clip, and the mounting brackets actually kind of go into it. Let me try to take that out with one hand whilst I'm filming. There you go. Okay, so you can see there's our mounting bracket there, and we've got this one part. It's a U-shaped mounting bracket. Usually mounting brackets are often just an L shape. This is a U-shaped one. So that part, you can see the part on the right that comes out here, that goes into the base of the brush clip, and then you can, obviously once that's in, these things, the reason why we got paper is this is very strong adhesive, and this can be kind of attached in whatever way to the head of the apparatus, and by the end of it, obviously you've got your floor cleaning apparatus and you've got this upward and an outward cleaning brush there. So this mounting bracket here, this is actually a later version where we got two mini brackets like this, but as you'll see in the pattern application, originally it was actually just one long U-shaped bracket that goes kind of along the whole length. So that's the kind of three main parts we got. We got the brush, which also has its spine, we got the brush clip for the brush to go into, and we then got a mounting bracket which kind of helps you mount the brush clip to the head of the apparatus. So that's Tom's preferred version of the brush up.
Let's now go to one of the patent drawings from Tom's US non-provisional patent application drafted by his US patent attorney. You can see the patent drawing on the left here, and I'll keep an image up of the version I just showed you on my smartphone video so you can compare the two. They're pretty much identical. You can see the parts. We've got the brush, the spine, which could be a rigid curved spine like the one I just showed you on my smartphone, or could be a flexi spine version like I mentioned that gets bent into position to create the same effect. We've got the brush clip that the spine is secured into, and a mounting bracket. And in the case of the patent drawing, the mounting bracket is a long mounting bracket that extends along the whole length of the brush up, rather than the two mini ones like the one I showed you on my phone. So there we are. The brush, the spine, the brush clip, and the mounting bracket for mounting it onto the head of the broom, vacuum, etc. Now let's take a look at the Claim 1 that Tom's patent attorney drafted and filed for Tom's US non-provisional patent application before I was involved. And this is where your crash course really starts. This is very, very important stuff. This claim will look a little bit weird to you. Again, don't worry about that, it's totally normal. Because I'm an inventor who learned this stuff from scratch after a serious injury, I can explain this to you in a way you can understand. Patent attorneys tend to struggle explaining how patenting works to inventors. I'm an inventor myself, so I know how to explain it to you, and I know what it's like from your point of view just starting out. What I'll do straight away is highlight the actual elements Tom's attorney included in the Claim 1. And that will make it look a bit more familiar to you straight away, because we've just mentioned some of these parts from the drawings. You may recognize them. It's important to realize that on an application like Tom's, the way your invention is described in your Claim 1 will actually define your patent protection. If you get the Claim 1 wrong and it goes to grant, you're in big trouble. It could lead to you getting patent protection that doesn't stop your competitors from stealing your inventive concept. So this is very, very important stuff. So the Claim 1 is just a funny way to describe what your invention is.
but the way you describe it will define the exact patent protection you get. So this is a precise and brutal art. You cannot afford a mistake here. You have to get it perfect. So let's take a look at the Claim 1 that was filed for Tom's invention, the brush up, and I'll show you what it means. This is the exact process your invention will go through if you try to get a patent. You'll also have a Claim 1 just like this. I'm going to put that patent drawing from the application up too, which will help you see what the claim means. If we look at the claim, Tom's attorney has defined the invention as an upstanding brush assembly. Assembly just means set of parts. So he's claiming the whole of this set of parts, and he calls it an assembly for attachment to a cleaning apparatus. So that just means that this assembly, all these set of parts, are for attaching to the vacuum or broom head, etc. Then he uses the word comprising, and this signifies that we're about to go into the list of elements that it's hoped Tom will get a patent for. This is how a claim works. You have to break your invention up into a list of parts it's made out of. And if that combination of parts is novel, i.e. no one has ever come up with that combination before, then you can get a patent on that combination of parts. So let's take a look at what the attorneys listed as those parts. And I really want you only to concentrate on the parts themselves which I've highlighted in red. The other stuff is not important right now. So we've got a brush element. Brush element just really means brush. We've got a brush clip for holding the brush. And we've got a mounting bracket. And those are what are called the essential elements of Tom's Claim 1. Now, what that means, and this is important, is that if Tom gets a US patent on this Claim 1, then if any competitors sell a product in the US that has all three of these elements, all three that are in his Claim 1, then he can successfully take them to court and get them blocked from selling the product. But they must have all three of those parts for him to be able to do that. All three things together. If they just have two of those three things, so let's say they just have a brush and a mounting bracket, but not a brush clip, then they are not infringing his patent. They have to have all three. So you will only be able to take competitors to court and win if their product has all of the elements listed in your claim. In this case, we've got just three elements in the Claim 1. So a competitor's product must have all three of these parts to be infringing Tom's patent if he gets this granted. This is where it gets a little bit interesting. Tom contacted me, and soon after that, he sent me his US patent application. I looked at Tom's Claim 1, just the same as we're doing right now, the one you've got right on your screen, and it worried me. I looked at the drawings, just as we've done, and I saw the brush element, the brush clip, and the mounting bracket. And yes, the version I showed you on my smartphone had all three of those parts. But let's take a look at another version that Tom had shown me and that we saw earlier. In this version, Tom had just cut a groove into the head of a broom, and he had slotted the rigid curved spine into the groove so that it was secure, and the brush up was working great. This part, by the way, in the center is nothing to do with attaching it, that's just a part of the broom, nothing to do with the invention. Tom believed he was going to get patent protection on all versions of his invention, including this one, any invention that used his concept of the brush up. And he thought that he was covered on everything in his US patent application. He wasn't expecting me to find a problem. But let's take a look at this version next to his Claim 1. Does it have all those 3 parts that are listed in his Claim 1? Well, it's got the brush element, so that's good. Then we've got the brush clip. Well, where's that? Where's the brush clip gone? In this version, there is no brush clip because the spine of the brush, and you can see a bit of the rigid curved spine jutting out of the side here, just goes straight into the broom without any brush clip needed. What this means is that this version of the invention is not protected by Tom's patent attorney drafted Claim 1. Let me just repeat that. Because this version of the invention does not have all 3 elements listed in the Claim 1, it is not protected by that Claim 1. So if that Claim 1 got granted, and that was the only patent Tom had, that would mean competitors have just been given the green light to steal his idea, because they'll just create a version of the brush up which doesn't have a brush clip. What's even worse is that this version, where the brush and spine go directly into the cleaning apparatus, was not shown in any of the drawings of his US application and was not mentioned at all in the application. That's not good news. Now, you might say that this was a bit of a homemade version by Tom. After all, he had just cut a groove into the wooden head of a broom, but this could easily be designed and mass-produced for any broom, vacuum, or anything else by a competing company. And even if they didn't use the groove idea to attach it, they could use any other way, maybe some sort of clip on the apparatus that the spine clips into. And as long as the brush up didn't have a brush clip, they would be free to compete with Tom and they would not be infringing his patent. What really worried me was the idea of the flexi-spine version of the brush up being able to be attached in this way with a modified groove or channel. That could be a great product, but it wasn't protected by the Claim 1 because it wouldn't have a brush clip either. Remember, you only get protection on products that have all the elements listed in your Claim 1. And that version wasn't shown in the drawings or mentioned in the application either. The problem is, because those versions of the invention weren't shown in the drawings or mentioned at all, they couldn't be claimed in the same application. And you can't add more stuff to a patent application once it's filed. So new drawings couldn't be added in. So it can be a real problem. So there's a problem here. We found out there are versions of the brush up that don't need to have a brush clip. And obviously, Tom wants protection on all those as well. So this patent, if granted, could be designed around. You may have heard this term, to design around a patent. This is what it means. It means if this patent was granted with this Claim 1, then Tom's competitors could design around his patent by creating and selling a version of his product, for example this one, that doesn't have one of the elements of his Claim 1. So they wouldn't be infringing his patent. That's what's called designing around a patent. And for all we know, this version may actually be more commercial, in which case you're in big, big trouble. It doesn't matter how good your patent attorney is, it doesn't matter how much money you've spent. And you cannot blame your patent attorney because they will have you sign an agreement before filing that you are happy with the application they have drafted. This is why patenting is so brutal. You have to get it perfect. So that's the problem with the brush clip. Although we already know we have a problem here, let's just take a look at the third element of the Claim 1, the mounting bracket. And there's a problem with the third element too. Does this version of Tom's invention have a mounting bracket? Well, I don't think it does. Tom's attorney did state in the application that the mounting bracket could be molded into the head, but the problem is, a bracket really suggests an L-shape or U-shape type bracket, something that connects to something and then has a protruding part that helps fit something else, just like a shelf bracket does. And this is exactly how it was shown and described in the application. A bracket that has a part jutting out that the brush clip attaches onto. But in this version, we have a channel or groove cut, or could be manufactured, into the head. So there's not really a mounting bracket here. But with this Claim 1, if granted, Tom will only get patent protection on versions of his invention where there is a brush clip, and a mounting bracket. All three must be there. No mounting bracket, no protection. No brush clip, no protection. In an application like this, you only get protection on inventions that have all the elements of your Claim 1. And in fact, if we jump forward in time, because this original US application was filed some time ago, the examination has progressed, and the Claim 1 that now looks set to be granted for this US application is even more limited in the way it defines the mounting bracket. Let me show you another of the original drawings to explain this. The Claim 1 that looks set to be granted now states that the mounting bracket must have a mounting flange, that's what Tom's attorney has called this part of the mounting bracket, and an attachment flange, that's this part of the mounting bracket that juts out for the brush clip to attach to. And because that's the Claim 1, it will only give Tom protection for versions of his invention that have a brush clip, and a mounting bracket that has a mounting flange and attachment flange that juts out like this. We already know the claim is defective because we don't need a brush clip. But just to show you how easy it is to design around this as an attachment system, what if I reversed this and had a jutting out attachment flange on the brush clip instead of the head of the apparatus, and a groove in the head of the apparatus that the jutting out part on the brush clip attaches into? That's just one easy way to design around the claim, but there are probably a dozen better ways. So you must be very, very careful with your Claim 1. Once all the dust settled, and I had told Tom, the way I went with patenting the brush up in the UK was very, very different. And although I went a bit over the top and drafted and filed a UK patent application more than 100 pages long, including 68 pages of written description and 50 drawings, it ended up being used as the basis for a continuation in part US application filed by Tom's US patent attorney for the brush-up. We've already had results from the UK IPO that the rigid version and flexi version, even without the brush clip, are novel, and you can imagine what good news that is to Tom. Me and Tom's patent attorney worked closely together on his US continuation in part application and came together to help Tom get the best protection he could get, which was extremely positive and led to a great Claim 1 being drafted. And Tom now looks set to get much broader protection for the brush-up. I won't go into this anymore at this point, but even if you don't understand a lot of what I'm saying, I hope you're starting to feel fear about this happening. You must feel fear because unfortunately there's a very significant chance this will happen to you. Fear will put you in the right frame of mind to stop this happening. So to make sure this doesn't happen to you, I've created a program that solves this problem. It's called iPerfect Patent, and it's an instant access digital program that shows you exactly how to get a perfect patent and how to stop this type of thing happening to you. But in iPerfect Patent, I'll show you exactly how to check your Claim 1 and even how to build one for your invention. This allows you to communicate with your patent attorney and correct the application if it's going to get you defective patent protection. If you don't do this, I believe your invention is in real, clear danger. What you've seen here with the brush-up is happening a huge amount of times, maybe 20 to 40%. So your invention is in real danger here. Remember, it doesn't matter how good your patent attorney is or how much you paid. It doesn't matter if your patent attorney was recommended by someone so you think you're okay. Tom's patent attorney is highly qualified and was recommended to him also. It is not the attorney's fault. It is your fault if this happens. You now know the problem and you know the solution. Fail to do it and your chance of getting perfect patent protection on your invention falls dramatically. And remember, something similar to this happened to me too. I had a patent attorney patent application before I got injured and learned how to patent my inventions myself. That patent attorney application I got amounted to nothing. So you are not immune. I always remember the advertisement for the film The Fly. It said, "Be afraid. Be very afraid." I'm sorry to be honest, but when it comes to patenting and getting defective or useless patent protection from a patent attorney, and losing the right to patent your invention perfectly, losing your dream, you should be afraid. You should be very afraid. This is the mentality that will help you stop it happening. You've seen it with your own eyes. It's down to you. This story had a happy ending. Tom found me and we were able to put it right. But I am not available for this type of work anymore. I am retired other than inventions I work on with SHIINE Design. So if you find yourself in the same situation as Tom, your story will not have a happy ending unless you get iPerfect Patent.